Chairman Wontumi ni new lawyer a yɛfrɛ no ɛyɛ Samuel Atta abusua ɛndra yɛba be breaki ɛde mama ɔkyerɛ sɛ o plead with the court na kyerɛ sɛ ɔmo change Chairman Wontumi ne judgment day no na according to court no ɔmo ate nsɛm a Samuel Atta ɔka nyinaa a ɛkyerɛ sɛ changes bi a ɔmo bɛyɛ ɛfa judgment day no na court no nso akyerɛ ɛyɛ Atta nso sɛ there is nothing that can change ɛyɛ saa 3rd July judgment day no matter what. Shiniwa ebetumi asesa eye judgment day nti no ne appeal anase plead a o plead court no abusua court no omo abo e de ato ba bia asese a chairman Wontumi otwe ne mu kosoro eba form a saa 3rd July judgment day no ebeba abonten nti no lawyer Atta case we na obesom no lawyer Andi Akyea could be not onim baby a case no ekikakọ na ose obetumi aso a nti no animgu ase ne de chinchirinchi lawyer Atta obe soa mome yanko na yankonkoti Alfred Okansi ne nsema ode tudwa efa Wontumi ene exim court honsensem ene 3rd July judgment day na ebekoso no mome yanko na yankonkoti yeba yadede aka ato amoso ebusu yansa na ebekoto no se open computer papa and a laptop papa na we use the Abura periodic computers and accessories eho ena ye computer papa fi ni location enya ira kwan owo Kumasi Buokrom Estate Eli Kumasi Buokrom Estate Eli ade ba ko a ede owo me se ukra low budget and ukra high budget obema high quality laptop na we use friend number ya ego e screen yi as 0247 030108 and answer 0597 942133. Periodic computers and accessories and a laptop papa FM.
And Chairman, want to me a bit further on the matter of the Samurai Boy case that the trial judge has indicated that by July 3 we should expect a judgment. And lawyer Justice Abdullah is joining us on Zoom as well for a quick one on this. Counsel, good evening. You've just heard the now new counsel for Chairman Wontumi, that's Samuel Atta, indicate that he's going to apply for at least some time to be able to apprise himself with this Samurai Boy case, that judgment is expected on July 3 because he just took over the case. But if you recall, last week, the trial judge was quite clear in her words that even if there's a change in the legal representation for Chairman Wontumi, she's still going to go ahead to pronounce judgment on July 3, right? How does that strike you?
So as far as I am concerned, it clearly shows that the court is reading into a possible mischief as the basis for this particular application. The timing is a bit, it creates this kind of suspicion. And then, I mean, hardly would you find that at the end of a trial, a lawyer is withdrawing from a suit. It creates too much suspicion for any judge, even where it is, I mean, it is not ill-intended. It comes across as mischievous. And so it's the reason for the intransigent position of the court. If this had happened anywhere mid of the case or the beginning of the case, it wouldn't reach the same level of suspicion that the judge is reading into this application. And so it is difficult to blame the judge for this stand. And so you can understand why things will go the way it has. What could be a reasonable ground for a lawyer having completed a trial to say that, well, I'm throwing in the towel at this moment, and that, I mean, what could be, and he has written, everything has been done, literally everything has been done, just awaiting judgment. You would need more than just your relationship with, I mean, the kind of conduct exhibited by a judge to be a basis to remove, I mean, to literally withdraw from such a suit. It's very difficult. There's really nothing for you to do at this point. So, so once you step out of the case, and then what happens? On the other hand, if you remain in the case, what happens? Like, literally, there is no gain, nothing to gain or nothing to lose in you remaining or leaving the matter. If anything, there's rather more gain if you remain because you have the conduct of the entire case. And so it is easier, assuming the case goes against your client, for you to mount an appeal because you have the entire circumstances and the facts and the evidence of the case on your fingertips. So you are better placed to serve the interest of your client on a possible appeal than any other lawyer. And so it is more beneficial, in other words, for you to remain in the case. So it's difficult to appreciate the mindset and the thoughts that went into the decision to withdraw. But sometimes when you're not in the cooler, you may probably not appreciate it as much as the person in there.
So, and Counsel, appreciate you for this. Thank you for joining us. Result or outcome after the High Court granted the party's request to progress. Benadenchi Bosiak, as you know, has been charged with defrauding by false pretenses, forgery, that's number 2, authorizing forged documents, and money laundering. These 4 charges in this loan deal with the Ghana Exim Bank. And this has been the subject of the plea bargain that his lawyer in this particular case, Akyea, has been speaking to the media after the court hearing today. Take a look.
As promised, it was a very swift interaction with the court. Both the Attorney General and Counsel for accused persons agreed that since we have initiated plea negotiations, it is only by law prudent for the court to give us an adjournment until we come to inform the court of developments. And by law, we are entitled to a 30-day of plea negotiations. So we agreed to take the 6th of July to come to the court to inform the court of progress so far in the plea negotiation. We are very hopeful that by the time we come to the court on the 6th, we will have made some progress and inform the court of what issues are left outstanding for us to clear and to file our plea agreement in the court. The mood of the court and the predisposition of counsel on both sides suggests that we will be able to reach an amicable settlement quickly for us to file a plea agreement that will bring the matter to finality.
Well, so that's Akyea there. As you do know, he has withdrawn his services regarding some of the cases related to Chairman Wontumi, and this specific one, the Samurai Boy illegal mining case. He is not the legal counsel for Chairman Wontumi anymore. We have an update on that one as well, where the court is expected to pronounce judgment on the 3rd of July 2026, in the next few days ahead of us, regarding this particular one, but we'll come to that shortly. Christian Mamhesi, private legal practitioner, is going to be joining us on the phone shortly regarding this particular one on the matter of the Exim Bank case. As we do know now, as you heard, that his lawyer, Akyea, in this particular case, indicating the court's position on their application for plea bargain and also what they expect going on. When I spoke to Akyea a few days back, he indicated that they are going in with a particular demand, and we'll get to that shortly. There's 14.3 million and over that Chairman Wontumi is reported to have fraudulently procured as a loan from the Ghana Exim Bank, which is the subject matter of this particular case, caused financial loss to the bank to the tune of over 30 million Ghana cedis. So that's the amount in issue in this case. Here are some of the options that could actually come out of this plea bargain. The path that Chairman Wontumi and his lawyers have taken. First off, as we do know, as enshrined in Section 162 of Act 29, specific to this particular case of the matter of plea bargain. We're going to get into it shortly, and when we get through to Christian Mamhesi on the telephone, we'll get some details specific to this. The Criminal and Other Offences Act, specific to Section 162B, on the matter of plea negotiation, subject to Section 162B, a person charged with a criminal offence may at any time before judgment negotiate with the Attorney General for a plea bargain. So keep that in mind. This specific to Act 30, that's Section 162B, to withdraw a charge against an accused person. So this is the option that Akyea is going for. It says they are going to seek a withdrawal of the charges, all the charges of forgery, so on, against Wontumi. This is what they're going to seek. As to whether that will be granted or the possible outcome of this plea bargain, the coming days is one to watch. There is also the option of the reduction of the offense charged to a lesser offense. Also, the reduction of the punishment for said offense charged within the law that prescribes the punishment. So these are possible outcomes. And then also, 162B gives details. That's 2B2. A plea agreement under subsection 1 may provide A, a sentence or a range of sentences to be recommended to the courts, and B, the payment by the accused person of compensation to a victim of the offense, or C, the making of restitution by the accused person with the prior consent of the accused person. So these are the possible outcomes and how things are going to play out in the courts regarding this particular plea negotiation that now the courts have granted Chairman Wontumi and his lawyers to, as it were, go ahead with it. There are so many views on it regarding whether or not the Attorney General should pay heed to it or allow the course of this case to run to its legal conclusion. Now, those who also believe that, well, if we're going to, like some Martin people say, if we're going to get this money involved, 30 million Ghana cedis, which is the central focus of the Operation Recover or Loot, recovering whatever money is in there that will benefit the nation in other ways, then that should be considered. But other people hold different views on it. Let's go on to the telephone lines right now and have a conversation with private legal practitioner Christian Mamhesi. Has been following this quite closely to see how this particular case proceeds going forward. But also in court earlier today regarding the Samurai Boy case that Chairman Wontumi as well is having to answer for, this particular Samurai Boy case, this one. That judgment is expected on July 3. His new lawyer or lead counsel on this particular case after Akyea withdrew his services is Samuel Akyea. And he had this to say regarding this July 3 judgment day for Chairman Wontumi. He says he wants more time. Take a look.
I've taken over the criminal case that lawyer Akyea was handling. That's what I've done. But the rest of the cases are not with me.
Counsel, is it the case that with the Samurai Boy case that the dates for the judgment were scheduled to July 3? With you taking over the case now, does it change the timelines?
I will play with the court for that. Because if you want to have fair trial and if you want our input as part of the thinking of the judge, I believe we should enlarge time so that we'll be able to do what is necessary.
Well, so we'll see whether this demand or the request, for more time by Samuel Akyea in this matter of the Samurai Boy case, that judgment is expected on July 3, will be granted by the courts because it says he just took over the case. He needs to apprise himself with the details and so on. But on this matter of the plea bargain, and Christian Mamhesi is private legal practitioner. Counsel, good evening. Thank you for joining us.
Thank having me. Good evening to your viewers.
Now, the courts have granted that application, the plea bargain by Chairman Wontumi's lawyers regarding this Exim Bank case. 30 million involved, a number of options at play regarding what could be the possible outcome of this plea bargain application that the courts have granted. How's the coming days going to look like?
Yes, I mean, with plea bargains, it comes directly under Act 1079, and that amendment allows for a party or accused person through his lawyers to negotiate with the Attorney General in matters of criminal matters. And just to mention, matters of treason, matters of murder or attempted murder, rape, defilement, kidnapping, robbery, genocide, these are considered serious offenses that cannot be negotiated under plea bargain. So plea bargain is a form of negotiation that allows for minimal sentencing in respect of an accused person, where the accused person has admitted in substance to the charges. And with plea bargaining, we can have the charge bargaining, we can also have the sentence bargaining or non-prosecution bargaining. So now, as the counsel for the accused person and the accused person himself were engaged the Attorney General, the act says that there should be openness, the charge sheet and other disclosures must be made available to them, and at no point in time should duress exist or promise or any form of coercion exist. It must be the free will of the accused person to negotiate at will. And in the circumstances, whatever they agree upon, a plea bargain agreement that will be drafted will be brought to the court to ascertain whether it would be in the interest of justice for the admission or adoption by the court. If the court is of the opinion that it has infringed on natural justice, the court would reject it. If the court is of opinion that the leniency granted is unconscionable, incorrigible, and again does not satisfy the test of justice, it would also further discount it or reject it. So, I mean, in substance, this is an opportunity for the accused person to negotiate with the Attorney General in order to have a lesser sentencing, and also how payments would be done in respect of whatever is posted on the face of the charge sheet.
Counsel, appreciate you for this. Thank you very much, giving us an outline of how the coming days will look like on this particular matter of the Exim Bank case involving Chairman Wontumi. Great. He's Christian Mamhesi, is private legal practitioner. Also, let's stay on.
She abusuan we ne ensema ekoso ewo political highway so eye Chairman Wontumi ne judgment day ne de abusuan oda onda ensem bebre na ebobo e de free mobile ye de edomo ye bedamase samoje pene kokotiza ensem we edemai.